How does a property being sold by an estate change the process? I would say only in every way. The owner of a property passes, either with a will or without a will. Regardless, the property goes into probate. So a personal representative or an executor or an executrix will actually pursue a probating of that estate. As a part of that process, the court will approve the sale of the property, either through what we call consent of heirs, which is all of the heirs of the estate being in agreement, or a power of sale in a will, or the court issuing what's called a license to sell. When we are representing the buyer of a property, when there is an estate involved, my first question always is, where are we in the process? Did they just file the petition to have the probate open and to have the estate open? Or are we nearing the end of that process? Do we have the license to sell that we need, or don't we? In terms of the closing process, it's a little different. The deed is typically what's called a fiduciary deed. It's a deed signed by a fiduciary, a representative of the estate. Sometimes heirs are involved. Sometimes at the closing, I'll be sitting in a closing table and there'll be 10, 15 people in the room. All of the heirs literally coming to the closing to sign a consent form, basically authorizing the transaction to go through. The check that's issued at closing is not made payable to a seller. It's typically payable to the estate. There are typically attorneys involved representing the estate. So it is a different process. There are more moving parts. There are more legal documents. We have to keep track of that probate case, docket number, details, deadlines. It's definitely a more complicated process, but very doable and something that we see a lot.